friends. I'm Jeffrey Rosen, President and CEO of the National Constitution Center, and welcome to We the People, a weekly show of constitutional debate. The National Constitution Center is a nonpartisan nonprofit chartered by Congress to increase awareness and understanding of the Constitution among the American people. This week, we'll discuss Richard Primus's new book, The Oldest Constitutional Question, Enumeration and Federal Power. Richard Primus is the Theodore J. St. Antoine Collegiate Professor of Law at the University of Michigan. And in addition to The Oldest Constitutional Question, he's written several important law review articles on the scope of congressional power. Richard, it's wonderful to welcome you to We the People.
Thanks for having me, Jeff. I'm delighted to be here.
And to dig into this topic, I'm honored to put Richard in conversation with another great scholar of congressional power. John Harrison is the James Madison Distinguished Professor of Law at the University of Virginia School of Law. He's the author of several important law review articles on a range of topics, including the Reconstruction Amendments, congressional power, and as I well remember from my earliest scholarly days, superb articles on the Privileges or Immunities Clause, which he's written about for the NCC's interactive constitution. John, it's wonderful to welcome you to We the People.
Thank you, Jeff. It's great to be here.
Richard, congrats on the book. Tell We the People listeners about your central argument in The Oldest Constitutional Question, Enumeration and Federal Power.
So there's a basic fundamental doctrine in constitutional law that says that Congress is a legislature of enumerated powers, meaning that the Constitution's text lists the subjects on which Congress can legislate, and it can make law on those things and no others. In this respect, it differs from state legislatures. The normal rule is that a state legislature can make any law that it isn't prohibited from making, either by the U.S. Constitution or other federal law or its own state constitution. Congress isn't like that. It faces the opposite default rule. There's a closed list of things that it can do, and it can only do what's on the list. The idea that Congress can only legislate on the basis of its enumerated powers is understood to go all the way back to the Constitutional Convention, to have been a constant principle through our constitutional history, to be required by the text of the Constitution, partly by the 10th Amendment. Some people also say by the first clause of Article 1, which introduces the topic of Congress and its powers. Some people say the very fact that Article 1, Section 8 contains a long list of specific powers establishes this principle, because why write a long list of particulars if Congress could in fact do things on the list or not? And it's also understood to be vitally important in the structure of American federalism. By keeping Congress to the things on the list, we maintain the appropriate balance of power between central and local authority in our system. This is all Con Law 101. It's basic. I teach it to my students every year. But I have come to think that there are real problems with this way of thinking about the power of Congress. I've come to think that this way of thinking, which following David Schwartz at the University of Wisconsin, I'm calling enumerationism, is not a way of thinking that the Constitution requires. It's one lens on the Constitution. It's a way of thinking about the constitutional text and constitutional history and federalism. And it's a problematic way of thinking about all those things. That is to say, I've come to think that the text of the Constitution doesn't really confine Congress to its enumerated powers, though we choose to read it as if it did, and that this historical story on which this is a principle established by the founders and maintained ever since is not really true, and that federalism, though enormously important, doesn't depend on limiting Congress to its enumerated powers. And part of why I think it doesn't depend on it is that the first thing the con law students learn is that Congress is limited to its enumerated powers. But the second thing they learn, or at least what they learn if they've been paying attention by the end of the semester, is in practice, that doesn't really seem like much of a constraint. In practice, for going on 100 years, Congress seems to be able to legislate on pretty much any topic for which it musters the political will. And yet we still have a federalist system. Right now, some people think that the way that Congress has been able to legislate broadly for the last 90 years or so is a problem. It means that the enumerated powers aren't doing their job, which is to confine Congress, and we need to be stingier about how we understand the enumerated powers. And I've come to think, no, we haven't all been doing it wrong for going on 100 years. The enumerated powers shouldn't really be conceptualized as a mechanism of limiting Congress, or at least not mostly. They should be conceived as a mechanism for empowering Congress and perhaps as a floor rather than a ceiling of what Congress can do. That's the basic idea.
Thank you so much for introducing the argument. John, what is your reaction to Richard's argument that enumeration was originally intended to be a way of empowering Congress rather than limiting it, and that the text of the Constitution doesn't confine Congress to its enumerated powers?
Well, Jeff, the first thing I want to say is that a great value of Richard's book and a lot of his work is to pull apart two issues that are different, that are often run together, and one of which is a lot easier than the other. And there's always a danger when you see something that has an easy answer to say, oh, that covers all the hard parts. And the first thing I would say is to say, I do think it's true that the national government has only the powers that are delegated or granted to it. But I think what Richard is objecting to is, I believe, a more contentious claim, which a more contestable claim too, which is that the specific enumeration in the Constitution, the list primarily in Article 1, Section 8, but it's elsewhere too, that is all that is delegated or all that is granted. And I think that a lot of the value of Richard's work recently has been to remind us that those are two different questions. And if you want to be an enumerationist, you can't just rely on the principle that I think almost everyone would agree with, which is federal power has to have a source. It has to be delegated. It has to be granted. And so I think the big question, and maybe the issue on which I would differ from Richard, the crucial question, I think, is, in addition to what's explicitly and specifically granted, is there anything else of much substance that's implicit, that comes with the Constitution but isn't anywhere on a list? That, I think, that's the crucial question, really, now, between enumerationism and, yes, I believe in delegated powers, but I believe there can be something else.
Well, I must say that one reason I was so excited to have this conversation is that the question about enumerated versus implied powers does seem to be the central question in American constitutional history. I have a new book coming out in October, The Pursuit of Liberty, How Hamilton versus Jefferson Ignited the Lasting Battle Over Power in America. And it argues that Hamilton and Jefferson's initial debate over the constitutionality of the Bank of the United States introduced this central question of implied versus enumerated powers, strict versus liberal construction of the Constitution that has defined our constitutional history ever since. Richard, a path-breaking claim in your book is that the debate over enumerationism came after the Constitutional Convention. You argued that at the convention itself, no one took the strict constructionist position that only Congress's enumerated powers were granted to it. And you suggest that, in fact, the nationalists championed enumeration as a way of empowering Congress rather than limiting it. Tell us more about your arguments about the Constitutional Convention and enumerationism.
So I want to be careful to be appropriately modest about what I think I can claim. A lot of people in our line of work confidently say things about the Constitutional Convention of the form, everyone thought, nobody thought, they argued this, they didn't argue that. And all of these claims tend to be problematic because our actual knowledge of what was and wasn't argued or thought at the convention is spotty, right? We have a few hundred pages of notes of debates from a summers-long conversation where people are talking to each other hours and hours of a day. It's a very fragmentary record. So I don't want to say no one thought that, right? I don't think anyone has a basis for saying that about almost anything. And in a summers-long conversation with several dozen people talking, probably someone is going to think almost anything, right? But what I do want to say about the convention is something like this. There is a traditional understanding of the design of the framers coming out of the convention, which is that they deliberately wrote the Constitution to enumerate Congress's powers so as to limit the powers of the federal government. That was the initial design, and in fact, that was the consensus initial design. And that is an understanding of what the framers at the convention intended that got a very big boost from leading Federalists in the ratification debate, right? People like James Wilson and sometimes Madison and others also, who were attempting to get the Constitution ratified. They were arguing to the public, right, buy our new Constitution. And they understood that the skeptics who they had to persuade were people who thought, okay, we know we need a better government than we had under the Articles of Confederation, but we're worried about a federal government that's too robust. What are the limits going to be on this thing? And one of the arguments they made was, well, these powers are all there is, right? There's nothing else, and that's going to be limiting. But there's very little evidence that they talked that way at the convention. I think the rubber really hits the road here. There's a very famous piece of our civic culture that's a story about why the framers omitted the Bill of Rights, right? The official story, as it comes down to us, is when the framers initially drafted the Constitution, didn't have a Bill of Rights, right? That's why the Bill of Rights comes in the form of amendments later on, and that the Federalists explained during the ratification debates, this is Hamilton and Federalist 84 and several other places, that there's no Bill of Rights in the Constitution because the thing that's supposed to limit the federal government and then protect everybody's rights is not a set of affirmative prohibitions like don't censor speech and don't abridge religious freedom. It's that the enumerated powers are themselves inherently limiting, and that it would be a mistake to start announcing prohibitions like don't censor people's speech, because that would imply that Congress had more power in the first place than was on the list. And that, I learned in high school and again in college and again in law school, that's why there was no Bill of Rights in the framers' Constitution. But it turns out that there's really no evidence that that was part of anyone's design at the Philadelphia Convention. That appears to be a story, as far as we can tell, that was told ex post by the Federalists when they were trying to get the Constitution ratified, as if they brought out the Constitution and people said, we don't like your Constitution, it has no Bill of Rights. And the Federalists had to scramble to come up with something that would excuse that. And they came up with, among other things, this story. But it was rationalization, right? It was an attempt to reposition the enumeration of powers as a limitation, which wasn't a consensus view of the convention while the convention was actually working. What was, I think, a well-understood view of the convention while they were working that has mostly dropped out of our consciousness about the enumeration of powers, it was a device for empowering Congress along two dimensions. First, against the states, but second, and crucially, against the president. That is to say, under the Articles of Confederation, the government of the United States was a single institution, just Congress. So a power of the United States was a power of Congress. The new Constitution created a three-branch government, which meant if a power was assigned to the federal government, you now had to ask, well, who exercises that power? And because they were creating an executive that might have all kinds of powers, it was necessary to specify when there was a power that could plausibly be thought of as executive, if the framers wanted it to be a power exercised by Congress, to say so definitively, this is a power of Congress. And there are a bunch of powers in Article 1, Section 8, like the power to declare war and various others, that I think we can pretty confidently say are in Article 1, Section 8, because the framers wanted to avoid the possible inference that they were powers of the president, so that it's a separation of powers device for those powers rather than a federalism device.
John, what is your response to Richard's claim that leading nationalist framers at the convention viewed enumeration as a way of empowering Congress, not limiting it, and they seemed to change their view during the ratification debates to get the thing ratified? And in particular, Richard argues that James Madison in 1787 was thinking of enumeration as a technology of empowerment. He had advised the Kentucky representative against enumeration as a way of limitation. In 1785, he had his main goal was to invigorate the national government, and he defended enumeration as a way of empowerment. And basically, he changed his mind in arguing for a Bill of Rights, and then definitively embraced enumeration as a form of limitation in the debate over the national bank. What's your response?
I think that first about the convention itself, that the dominant bloc at the convention were nationalists to a substantial degree. They wanted to make the national government a lot more powerful. They wanted to make it structurally, as they thought, sound with a proper separation of powers. And so, to that extent, to a substantial extent, enumerating powers was a means of empowerment. I think it's also true, though, that for a substantial number of the framers, for a substantial number of the state delegations, that indefinite federal power was something that bothered them because they thought it could be used in ways that wouldn't be favorable for them, for their constituents. And so specification was both empowerment and a way of moving beyond indefinite principles and saying, here are the particular ways that we're going to empower the government. And they started, the list in Article 1, Section 8, starts with the two most important powers. And they wanted those to be definite. That's the taxing power and the commerce power. And again, they both wanted to empower, but they had concerns about an undefined federal power. And I think the system they ended up with, although it's not exactly enumerationist as that would be understood today, and as Richard understands it, has substantial elements of that, in large part because of that combination of desire to empower and worry about leaving something undefined.
Well, Richard, let's focus on James Madison. Might he support John's suggestion that specification was both a method of empowerment and resisting the idea of unlimited power? As you note, he embraced a version of enumerationism most dramatically in Congress when he resisted the idea that Congress had the constitutional power to charter a national bank. And his position was then embraced by Jefferson in his memo to George Washington opposing the constitutionality of the bank. Hamilton opposed it, and John Marshall and Washington sided with Hamilton and not Jefferson and Madison. But might Madison's, you call it an evolution, but might it support John's suggestion?
I think in part, yes. I mean, Madison thought a bunch of different things at a bunch of different times, and there's a rich literature that tries to figure out when he changed his mind about what. For the most part, I'm willing to give him the benefit of the doubt and say that he changed his mind because he came to think differently about things over time. It's good to be an active thinker and to be willing to revise your ideas, right, as things go. James Madison's super famous idea in Federalist 10 about the extended republic, he recanted by 1791 once he saw the machine in operation and said, actually, this is not working out the way I expected. So there is a lot of that. And I think that I'm relatively confident that he was of a more nationalist bent in the convention, especially early at the convention, and of a significantly less nationalist bent by the time he's arguing about the bank. And I think I'm on common ground with most scholars there. And then there are disagreements about exactly when he crosses over what threshold in between and what motivates him to do so. I think that it makes a lot of sense to say the enumeration of powers was never for just one thing. It's not that it's for empowerment and not limitation, right? Different people could understand it both ways, and thoughtful people could understand that it's doing both things at the same time. And the questions are, how much is it doing one and how much is it doing in the other? And in what way is it doing one and in what way is it doing the other? I think that the Constitution was not written to require clear answers to these questions. I think it was written to be ambiguous, to be susceptible of both more and less enumerationist readings, in part because not everyone in the room agreed on what the answer should be, and in part because people in the room who did know what they thought the answer should be weren't sure that that would be the easiest thing to get accepted by the public. So I think the convention gave us an indeterminate text. I think Madison's argument against the bank is one way to read that text that he came to sometime after the convention. And it's been a paradigm for a certain way to argue about the Constitution ever since. It wasn't persuasive to his audience when he argued it, right? Madison loses the bank debate. And there are questions about whether he loses the bank debate because people don't agree with him that Congress is limited to its enumerated powers, or whether he loses the bank debate because people agree with him about enumerated powers, but they have a more capacious understanding of the enumerated powers than Madison did, right? It's not clear that we can know for sure, based on the records, which of those things is the better interpretation.
John, Madison, of course, changed his mind frequently in his career. And on the question of the bank, he changed his mind again. As president, although he had initially viewed it as unconstitutional, he signed the Recharter because he thought that Congress and the people had come to accept the constitutionality of the bank in the intervening years. And that notion that the constitutional meaning could shift in light of the changed liquidation is one word that's used, or shifting understanding of Congress and the people, was at the core of his constitutional interpretation. Does that suggest that Madison, in the end, was not a strict constructionist and didn't think that the words of the text should be construed to strictly limit power, and that, in fact, the changed understanding should ultimately be decisive?
I think that is a great question, and thank you for raising strict constructionism, because I think that's part of the story, not only in general, but in particular with respect to the bank. Because I think, it's always difficult to reconstruct the thought of somebody who was both a theorist and an active statesman like Madison was. But I think that strict construction of enumerated powers, which eventually became sort of the orthodoxy of the Jefferson-Madison Democratic-Republican Party, that position is one that they came to during the 1790s, and it's a step beyond saying there's no indefinite power. Because it's the question, okay, there are definite powers, including the power to borrow money and the necessary and proper power. Does that mean that Congress can create a bank so that people can pool their capital and the federal government can borrow from it? And one of the leading arguments in favor of the bank was, yes, that's right. And that's a legitimate construction of the actually enumerated powers. And I think it was only when people like Madison and Jefferson started thinking about that they started to come to the conclusion that, saying that there's no indefinite federal power isn't enough to have a government that's limited in the way we want to be. We need to take a more confined view of the powers that are enumerated, and in particular, the power to implement other powers, the necessary and proper power. I think that's what was going on with Madison in the bank and in the 1790s. And I think he would have said, and that's consistent with the idea of liquidation, because these are contestable interpretive questions. What should be the principles of construction? How should they be applied? And if the people and the government have come to rest on an answer to that question, well, that's liquidated. That's the answer, but it only tells us what the answer to that question is. So I think he saw himself as consistent, and I think there's a way to see him as consistent.
Richard, let's talk more about that debate between Hamilton and Jefferson Madison about strict construction. Jefferson first raises the idea of strictly construing the necessary and proper clause in his memo to George Washington on the bank. Washington sides with Hamilton. Then John Marshall in McCulloch and Maryland explicitly embraces Hamilton's view and paraphrases it almost word for word and rejects strict construction. As far as I can tell, it was Jefferson's response to McCulloch where he really digs in on strict construction, in particular in a letter in the 1820s to Justice Johnson, where he sets out two canons of construing the Constitution. He says, first, judges should view it as a compact among the states rather than a consolidated national government. And second, he says, on every question of construction, we should carry ourselves back to the time when the Constitution was adopted, recollect the spirit manifested in the debate, and conform to the probable one. But then he says that it should be construed with the goal of protecting state sovereignty rather than empowering the national government. Broadly, is that right, that it was Jefferson who really introduces this idea of strict construction? And what does that tell us about enumerationism more generally?
Well, I mean, he's definitely a patron saint of the idea, right? And Madison does a lot of working it out for him also. And then there's a coterie of other people who are less famous, right, who are working in similar veins within their party. A lot of what's going on there is the fundamental question about whether the government of the United States should be understood as sort of a limited purpose venture or an organic entity, right, a real thing unto itself. And that was a fighting issue, right? I mean, quite literally, right? In the 1860s, that is a fighting issue. And it mattered a great deal in Jefferson's generation, precisely because if you conceived of the United States as sort of like a limited joint venture, it was much more plausible than to say it has these specific powers delegated to it and nothing else. If you think of it as a genuine national government, you might think, well, like national governments, like that's a thing that exists in the world, right? Under the law of nations, in the community of civilized nations, in the nature of human society, it's got to be able to do some sorts of things. So there were a bunch of people who would say things like, well, suppose there were no declare war power enumerated in the Constitution. It's got to be the case that the United States can declare war, right? Same with like raising an army or, various other things, right, that national governments do. In the wake of the Civil War, this reaches the Supreme Court on the question of whether Congress can create paper money, right, as legal tender in the legal tender cases. And the court says, well, among other things, that's one of the things that national governments do. And what we have is a national government, which they're willing to say in a much more full-throated way after the Civil War than before. There's a very complicated relationship between all of this and slavery, which I don't want to try to boil down to like one single point, but part of the story importantly goes like this. The southern states that are slaveholding states understand that if there's going to be an entity strong enough to end slavery one day over the objections of the southern states, it's going to be the national government. There isn't some other thing that's going to be able to do that. And therefore, if they are concerned, as they were, that public opinion would run against slavery and that issue would be forced, it was very important to them that the federal government be kept weak enough that it would not be powerful enough to overcome determined Southern desires to maintain slavery. That's not the only reason, right, animating this idea, but it was one important one, and it's certainly one that lines up with Jefferson on one side and Hamilton on the other. The slavery issue goes away with the Civil War and Reconstruction. The theoretical debate does not, right? The theoretical debate continues, and then we get a very interesting, ironic development later on. And here I want to pick up on something that John said about strict construction. It's one thing to say Congress can only legislate on the basis of this set of powers. It's another thing to say, and that set of powers must collectively be limiting, right? Must actually keep Congress from doing a bunch of things. One of the things that Jefferson figured out, right, as John reminded us, which the anti-federalists also pointed out during the ratification debates, is, these enumerated powers, there are a lot of them. And some of them are kind of broad. And read for all their worth, they would let Congress legislate pretty much the same as if Congress were a government of general jurisdiction. And my sense is that what happened in the New Deal was that the Supreme Court gave us a set of constructions of the enumerated powers broad enough that it was unnecessary anymore to resort to implied, non-enumerated powers in order for Congress to do the things that a national government would do. That before the New Deal, there was an era in which the Supreme Court frequently would forthrightly say that something was a power of Congress without worrying about whether it was enumerated. It was a regime of implied powers. Since the New Deal, we've mostly not had a regime of implied powers, but I think that's largely because we haven't needed one, because the enumerated powers have been construed broadly enough to make implied powers superfluous.
John, tell us more about your views about the genesis of strict constructionism. Is it right that it was Jefferson's response to McCulloch that was central? He was corresponding with people like John Taylor of Caroline, the most radical spokesman of the Virginia school, who published this strict constructionist tract called Construction Construed. And Jefferson says, I endorse every tittle of it. And if that's the case, is it right that that view is hotly contested by Hamilton and John Marshall and the Nationalists, and that initial debate about implied versus strict construction goes back to McCulloch?
I would say it goes back even farther than that. That because the bank was so controversial, but the first bank and the second bank were so controversial, those became focal points at which strict construction was debated, and in particular because even without indefinite general federal sovereignty, there's a pretty good implementing argument in favor of the bank. The bank helps the national government carry on a lot of its functions that are clearly called for by the Constitution. And so there's a reason that the fight over the bank became a fight over strict construction going back to the 1790s. And continuing through, and then creating the second bank, and then the renewed fight over the second bank, so that by the time Jefferson was writing in those days, he was sort of codifying Jeffersonian thinking that had been building for a couple of decades. Another thing I want to make sure to say about strict construction is that although Jefferson believed in the compact theory of the Union, there were certainly a lot of people we would think of as Jeffersonians in the antebellum period, like, for example, Andrew Jackson, who hated the Bank of the United States, believed that the national government within its limited sphere was a genuine sovereign. That's sort of sometimes called states' rights nationalism. States have rights, the national government has rights. They are both sovereign, they have separate spheres, but it's very hard, if you accept Jefferson's view, to take a broad view of federal power, but you can take a narrow view of federal power while rejecting the compact theory, the way Jackson and people who agreed with him did. And the last thing I'll say on that I think is really interesting and something Richard was talking about is after the Civil War, having won the war, the Republicans said we fought on the principle that the national government is sovereign too. And we won. And they said things like, yes, the national government is sovereign for international purposes. Yes, it can have a currency because sovereigns do that. And they still believed in substantial federalism type restraints on federal internal regulatory power.
Many thanks for that. And for raising the important point that it was possible to embrace states' rights nationalism while rejecting the compact theory and the constitutionality of secession. And as you say, Andrew Jackson and Madison himself took that position, putting them in opposition to Jefferson, who endorsed secession. Richard, help our listeners understand the relevance of these important debates to current questions. Is it right to say that these questions of implied power versus enumerated power, the sovereignty of the Union versus the sovereignty of the states, and whether or not to construe the Constitution strictly or liberally, go back to the beginning? There's no single original understanding of them. It's Hamilton versus Jefferson and Jackson versus Madison and so forth. And in fact, Justice Scalia, when he was appointed, said that he was a textualist and originalist, but not a strict constructionist. He believed in implied powers and liberal construction, in contrast to Justice Thomas, who embraced strict construction. Does this debate go back to the very beginning with no single consensus or answer?
It goes back all the way to the beginning, and it's possible to combine the positions kaleidoscopically in any number of ways, right? As you say here at the end, there's no reason why someone who's a constitutional textualist needs to be a strict constructionist, right? Strict constructionism is a version of textualism, but there are many versions of textualism, right? Because the text can be read, many different ways. So it's much more important than the question, I think, of like whether one is a textualist or not, is the question, what kind of textualist are you, right? And what are your reasons for reading that way? But yes, it certainly goes all the way back. And one of the things that I do in the book is I show how there are ways of reading the text of the Constitution that would make the enumerationist picture plausible. But there are also ways of reading the constitutional text that would make the enumerationist picture unnecessary or even hard to maintain. And that one of the interesting things is that we as a professional culture have persuaded ourselves, for the most part, that there is one right way to read the text, that the text establishes enumerationism as a factual matter, sort of on par with the proposition, the text of the Constitution is written in English, is the proposition, the text of the Constitution establishes the idea that Congress is limited to its enumerated power. But I don't think the text does that. And so the book, in a number of ways, walks the reader through the ways in which the text actually doesn't need to mean that. That's a lens that we have on it rather than a thing that we are required to read from it.
John, what do you think of that argument that there are ways of reading the text that support enumerationism or not, and that there's not just one way of saying that it compels a reading of enumerated powers?
I think that's right. I don't believe that the Constitution implies general federal power, indefinite federal power, but I also think that that's a conclusion that has to be reasoned to. That's a conclusion that isn't, Richard's right, that isn't a conclusion you can just read off the text. And it's a failing to think that the answer to that really hard question can be found so easily simply by saying, oh yes, there is a list. I think the presence of the list is important. It is evidence. It tells you something about what's going on. But I agree, these questions are harder than a lot of people think they are. And one of the benefits of scholarship like Richard's is to remind us that these are questions that have to be thought about. These are conclusions that have to be reasoned to.
Richard, what are some of the current interpretive consequences of your important scholarship for a judge who thinks the text should be construed in light of its original public meaning? As we've been discussing, there's this very basic, fierce debate from the very beginning about whether or not it should be liberally or strictly construed. So, and there may be no single right answer, but what light does your important history cast on what the right answer is?
Yeah. So I am not a public meaning originalist, or I'm not a public meaning originalist if public meaning originalist means what most people think of when they think of public meaning originalists. So it's not actually my purpose in the book to explain what such a person ought to think. But if I work myself into that frame and ask myself, suppose a public meaning originalist comes to me and says, suppose I accept this account of the history that you're giving, what should it tell me? I think what it should tell you is you're trying to do something that's much harder than you might have appreciated. You might be looking for an answer that isn't there. If you think that there is an original public meaning of the Constitution that existed as a matter of fact about whether the Constitution limits Congress to this set of powers or not, and then what to do from there, what I want to tell you is there were a lot of different people thinking a lot of different things, and that no decision that was made at the time authoritatively settled that question. The ratification debates decided that the Constitution would be law, but they didn't settle the question of what the Constitution would mean, right? It's a mistake to think that everyone who voted for ratification shared a view of how the Constitution would be interpreted and implemented afterward. Things never worked that way, and it's very hard to read the records we have of the ratification debates that way. The records look like there were interpretive disagreements at the beginning of the process, and there were interpretive disagreements at the end. There's a tradition in constitutional law of saying that where the Federalists offered narrowing constructions of the Constitution during the ratification debates, those are the interpretations that we should take the ratification to have established authoritatively, because that's what the public thought it was buying, right? You can think of it in reliance terms or in concession terms, right? That's sort of the idea. And I think this is a just so story. I think it's a just so story for a few different reasons. The first is we don't actually have any record of anyone saying, you know, I thought this Constitution was going to give the government a lot more power than James Madison says it's going to give it to, and I would have voted against it if that were true. But Madison now assures me that actually the government is limited to its enumerated powers, and I trust the guy, so I'm going to vote yes. We don't have a record of people doing that, and I think that it would be a relatively naive ratifier in the Virginia Convention who would think that he could rely on those sorts of representations offered at that moment. I think more instructive is the kind of conscious ambiguity and risk-taking that we see in someone like Edmund Randolph, who had been the governor of Virginia, who gives a very interesting speech at the end of the Virginia Ratifying Convention. He went back and forth on the Constitution during the process. Sometimes he's for it, sometimes he gets. In the end, he votes to ratify. And he says very plainly at the end, look, I realize that in the nature of things, a constitution like this might give us a federal government that is more powerful than I would want. But I'm going to vote for it anyway because I think it's worth the risk, right? Because there's no certainty of what will happen if we say yes, and there's no certainty if we say no. And this is a risk of voting yes. And that's the risk that I think is the better risk to take. And I think if we understand the founding generation as itself fighting about these questions rather than as having decided something, and the ratifiers as ratifying in the knowledge that they were not thereby settling the future, we make it a lot harder to think that modern decision makers can avoid the responsibility of figuring out how best to decide these questions by saying, I'm just going to implement a decision that somebody made a long time ago.
John, if it's true, as we've been discussing, that there was essential disagreement among the major framers and ratifiers about implied versus strict construction, then how does originalism constrain as a methodology? Do you agree or not that there was no single original public meaning on the question of liberal versus strict construction? It was essentially contested. And in that case, what should a judge who embraces original public meaning do on this central question?
Well, I think that the fact that there was contestation, that there is uncertainty, doesn't mean that there is no original public meaning. It just means there's more uncertainty, and it's going to be reasonable people are going to differ about what the original public meaning was. So, and I think sometimes originalism is oversold. Some of the sort of advocates of the most recent round of talk about originalism said, oh, the great thing about originalism is it avoids having to make all these hard choices and it just gives determinate answers. I think now, 30 or 40 years later, we're saying, well, maybe it makes some things easier, but by no means does it make everything easier. And so to say that there are difficulties, to say that there's a lot of uncertainty and that people are going to differ, isn't to say that the inquiry is meaningless and pointless, that there is nothing there to be understood. And I think Richard's point about some of the framers being prepared to take risks tells us something. They understood that when there is uncertainty about what something means, that means that one possibility, depending on who ends up being in charge of deciding how to implement the legal rules, one possibility is that you're going to lose out even if you think you have the better argument. Even if you think, no, I'm right about this meaning, and James Wilson and those who believe in substantial implicit sovereign power are just wrong, you have to understand, as somebody like Edmund Randolph, I think, did understand, but that doesn't mean I'm necessarily going to win. But I think it's important to see that somebody could say, I think I'm right, but I realize that because this is contestable, depending on who ends up making the decisions, I might not get what I think is the right answer.
Richard, if it's right that the question of liberal versus strict construction was essentially contested from the beginning, your book does seem to argue that the broad weight of the evidence was in favor of liberal construction and implied powers, and that indeed even those who at times embraced enumerationism did so strategically without abandoning their broader idea that Congress wasn't limited to enumerated powers. Would you say on balance, if a judge had to choose liberal versus strict construction, that liberal construction by far has the weight of evidence behind it?
Well, if we're talking about a lower court judge in the year 2025, I don't think I would say that. I think that lower court judges should mostly be in the business of implementing doctrine. Doctrine is like a worked out set of ways of approaching problems over time that we use to adjudicate the questions that come up. And I don't think that a good judiciary is one where lower court judges are freelancing in the archives to decide what they think the best historical interpretations of things that they're not all that well versed in are. I think that we have a hierarchically organized judiciary for a reason. And so I would not encourage judges to do that. But I also think that if judges approached questions of congressional power in the way that I hope they would, that wouldn't matter very much, because the existing doctrines about congressional power are sufficiently broad that if they're applied straightforwardly, we are rarely, if ever, going to see a federal statute that wouldn't be within the powers of Congress, even if you took an enumerationist view. Now, I want to be clear. Lots of things that Congress might enact are unconstitutional because they violate affirmative prohibitions, right? They violate the First Amendment, or they violate the Eighth Amendment, or they violate the Fifth Amendment, or the anti-commandeering doctrine, or all sorts of other things, right? There are affirmative prohibitions. But laws that judges should say are unconstitutional because they're beyond the enumerated powers is a really small category, given the constructions of powers that we have. When the Affordable Care Act was adjudicated the first time at the Supreme Court, the single most powerful argument against the constitutionality of the law was the idea that if Congress can do this, there's nothing that's not within the enumerated powers. And for many people, that was basically conclusive proof that this statute couldn't be within the enumerated powers, because there's got to be something that's not. It's fundamentally important to federalism that there's something that's outside the enumerated powers. And I think that's a bad argument, right? I think that one of the consequences of enumerationism is that judges sometimes go looking for laws that they can say are beyond the enumerated powers so that they can understand themselves as people who take seriously the official theory on which the enumeration is limiting. I think if we were to understand that the text and the history don't require that approach, and that federalism doesn't require that approach either, then judges would be less likely to go looking for opportunities to make that statement. And I think that would be a good thing.
John, a version of the same question to you, but more directly. Should a Supreme Court justice who considers him or herself an originalist embrace liberal or strict construction? In light of Richard's evidence, wasn't Justice Scalia correct to say that he sided with Hamilton, Marshall, and liberal construction? And wasn't Justice Thomas wrong to side with Jefferson and strict construction, given the balance of the evidence?
I think that the first thing to see about that is that strict and liberal construction and similar principles about how to decide have to be understood as being themselves distinct from the content of the Constitution. They are ways of finding the content of the Constitution. And I think that it's easy to run those two together. It's important to keep them separate and to say, well, like all of us, for a judge, anybody else, I'm fallible, I'm going to make mistakes. What principles should I adopt that I understand not to be the Constitution, but to be a guide for how to apply it in concrete situations? What principles should I adopt to manage my errors, to make as few and as less damaging errors as I can? I think that the first thing to say about principles like that is that's the kind of idea that's behind that. And I don't think we can say that there's a strong tradition from the very early days of liberal construction that would say, yes, that's an established principle that everybody involved in applying the Constitution should look to. And so I think that over the decades, judges and other deciders in Congress and the executive branch have had to sort that out for themselves. And there, I think, although Jeffersonian strict construction goes too far in one direction, I would not say, oh yeah, liberal construction in the sense of anything that looks like a kind of maybe connection. So if you're talking about the necessary and proper clause implementing the powers is enough. And so I think decision makers should take not a strict constructionist, but I need a pretty good reason to believe this, and in particular about the means-ends relationships that are crucial in implementing the necessary and proper power, that a decision maker should say, I should be pretty confident that if I do this, I'm going to be pursuing and achieving the end that I'm allowed to. I don't say that I wouldn't, again, describe that as strict construction, but I would certainly not describe it as liberal or loose construction either.
Many thanks for that. Well, it's time for closing thoughts in this great discussion. Richard, what are the big ideas that you want we the people listeners to take away from your important new book?
Well, the first thing I want to do is thank John for the conversation. John is not just an expert interlocutor, but an exceptionally thoughtful one, and I'm always grateful to be in conversation with him. I would say, to take away from the book, it's not my argument that what you're calling liberal construction or anything that I'm talking about as a non-enumerationist view of congressional power has been the official story of constitutional law. It hasn't been, for the most part, right? Certainly for close to 100 years, and in many respects for much longer, the official story has been enumerationist. A large part of what the book tries to show is that our practice has not been enumerationist, even as our official theory has been. So you bring us back a number of times quite appropriately to Jefferson. Jefferson, the strict constructionist, is also the man who bought Louisiana, on the understanding in his own mind that he had no constitutional power to do so, right? That is to say, even he could not walk the walk, right, when presented with the actual imperatives of governance. And I don't think that's a blip. I think that's how it's basically always been. I think Jefferson with Louisiana or Madison with the bank, or various other things that have come up later, over and over again, we have managed to understand one way or another our way to letting Congress do what Congress has the political will and the democratic support to do, subject to the affirmative rights protecting and sometimes federalism protecting constraints of the Constitution, like the speech rule and the religion rule and the commandeering rule and so forth. And those rules are enormously important. What I want to do in the book is to say we have a long-running disjuncture between the official story we tell and how we have actually done things in the system. And I think that disjuncture doesn't mean that we've been doing it all wrong all this time. I think it means that we've been talking in a way that hasn't really fully been thought through critically. And I would like to invite people to think it through critically, and in the best case scenario, maybe bring the way we talk in line with what I think is our quite sensible practice. And in the second best case, to be comfortable with the tension rather than saying we have to change our practices to conform with a problematic story.
Many thanks for that. John, I'd like to join Richard in thanking you for your generosity and joining us for this great conversation. What are some final thoughts you'd like to share with We the People listeners on Richard's important new book, The Oldest Constitutional Question?
Well, thank you. And the first thing I want to say is I want to thank Richard for this book and say, sometimes I agree with him, often I don't, but this is the way it's supposed to be done. This is what thinking about the American constitutional system should look like. It's well-informed. It is carefully thought out. It is a model of constitutional thought. The other thing I will say, in keeping with what Richard said a minute ago, is the disjunction between the official story, which is one of enumerated powers, but loose construction of the enumerated powers. The disjunction between that and another story that maybe some people really believe in, which is, no, the national government does have indefinite power to do whatever the country needs to be done, is, I think, instructive. It tells us that, and I think I differ with Richard on this, that there is a long-running, long-term commitment to the idea that the national government isn't just about whatever there is the political will to do at the national level, that there are some principles that limit the national government, and that sometimes the appropriate solution is to add a power. Never forget about the constitutional amendment process in thinking about the Constitution in general and the power of the national government. And I think one unfortunate consequence of the way the New Deal Supreme Court, the New Deal Justice Department talked at least and maybe thought about federal power is they put aside the possibility of backing and trying to draft constitutional amendments that would make clear that Congress has these powers, for example, the power to create a system of social insurance, social security, about which now there is, I think, a very substantial political consensus. I think the country would be better off if the process had included a rethinking at a very high level of the allocation of power between the national government and the states. And unfortunately, we haven't had that in a long time.
Thank you so much, Richard Primus and John Harrison, for a thoughtful, deep, and model of a civil conversation about Richard Primus's great new book, The Oldest Constitutional Question, Enumeration and Federal Power. Richard, John, thank you so much for joining.
Jeff, thanks for having us. John, thanks for the conversation.
Jeff, Richard, thank you. This was wonderful.
This episode was produced by Bill Pollack and Griffin Ritchie. It was engineered by Bill Pollack. Research was provided by Yuha Lee, Griffin Ritchie, Trey Sullivan, and Tristan Worsham. Please recommend the show to friends, colleagues, or anyone anywhere who's eager, hungry, and determined to enjoy a weekly dose of constitutional illumination and debate. Please check out the Constitution 101 course and anticipate eagerly, as all of us are, the new civic toolkit that the NCC is launching in September. That's September 17th, Constitution Day, and it's going to be an extraordinary collection of America's greatest historians writing about the big principles of the American idea. And always remember that the National Constitution Center is a private nonprofit. We rely on your generosity, passion, and engagement for all of our programming. Please consider donating at constitutioncenter.org/donate. On behalf of the National Constitution Center, I'm Jeffrey Rosen.